State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Michael Winquist in person in custody with counsel Eugene Harrington. We're set today in this matter for the sentencing portion of this case.
My relationship to Christina is her mother.
All right, you may begin.
Well, I mean, really, what can I say? I mean, Christina has been shot. She's had to go to the doctor several times. Don't quote me on this, but I think it was like 34 times out of 30 days that she was at the doctor. It's caused a huge hardship within our family. What can you say? My daughter's been shot. Yeah, she may look normal, but she's not normal inside. Her cognitive ability is not there.
This is the reality of gun violence that never makes the headlines after day one. Survival doesn't mean recovery. The court is hearing about permanent brain injury, daily medical visits, and a family that will never go back to normal. Let me ask you, how do you even begin to measure justice when the damage is lifelong?
And then you expect her to live a life, and the rest of us to live that life as well. She's not okay. And, let's get back to where, the very beginning of really what happened and what's gone on. And that's what I expect the council to do. Thank you.
Thank you.
I struggle with it just for the simple fact that, a lot of things I don't remember. And anytime that I think about Mike, everything just goes blank. I'm definitely nervous about what I should say or what I shouldn't say for fear of what will happen once he gets out, because I'm unable to file a restraining order at that time. But, one of the big things that, has not been brought up at all is Mike was shot. And I took care of him throughout the whole entire time. I didn't have that. Like they say, my life is not the same. My whole family's been impacted by this. And I feel bad because I'm like a burden. The other thing too that's pretty hard is that he could have very well taken another parent for my children. And the thought of that for them is just unbearable. And I'm not the same. I mean, people keep telling me I'm not the same. I don't feel the same. I guess, Debbie? Can you? Yeah.
Notice what she says here, not just trauma, but fear of the future. She's afraid of what happens when he gets out. That matters legally. Sentencing isn't just about what happened, it's about what could happen again. Should fear alone influence how long someone stays locked up?
Is that all you would like to say today?
She's going to have Debbie finish for her.
Right. Okay. And that's totally appropriate and fine. If you are going to read something, please read it slowly.
I will.
Thank you.
Okay.
The one thing that bothers all of us here, I think, is there has never been an attempt for any apology. There has never been any show of remorse. And the fact that they're saying that he didn't really know what happened, pardon my French, he's full of shit. And I apologize for that. There is one thing that Christina came across that I wanted to read as though I'm Christina. You were not my partner. You were my punishment. You didn't love me. You drained me. And yet I called it romance. You didn't hold me. You caged me. And I mistook the bars for a warm embrace. You weren't my partner in life. You were the tax I paid for ignoring my worth. I prayed for love, and life handed me a lesson in scars. That wasn't fate, it was a mirror. It wasn't chosen, I wasn't chosen, I was targeted. My kindness made me a canvas for your cruelty, and my silence gave you power. And the worst part, I loved you deeply, but not anymore, not anymore. That's it. Thank you.
That poem just reframed the entire case. This isn't just a shooting, it's control, emotional abuse, and psychological imprisonment. Judges are trained to filter emotion, but moments like this cut straight through legal language. Do you think statements like this should influence sentencing, or should courts stay purely clinical?
Thank you. Ms. Fickbaum, are you sure that you don't have anything else to say? All right, thank you.
I'm here on behalf of Christina Fickbaum. She is actually not very much able to speak for herself. And the one statement that I would like to leave the court with, more than anything, is that she is asking for the highest amount of sentencing that can be provided under what he has already said guilty to. And that is it.
Judge, my understanding is the Department of Corrections recommended essentially 16 and a half years.
Well, they gave a range is the thing, so I was including the range.
If you go to the maximum range, it's 16 and a half years.
Oh, well, regardless, my recommendation is going to be the upper end of what I'm capped at. It's going to be 17 and a half in and 10 out, which is relatively close to what DOC recommended. In Wisconsin, for any case, for any sentence, the court must always consider probation first. It must consider something called the McCleary-Gallion factors, which is the gravity of the offense, the character of the offender, and the need to protect the public. This is a case where Michael Winquist shot Christina Fickbaum in the head with a shotgun, not outside, not during like a hunting incident or cleaning a weapon, but for no reason at all. It was done in the kitchen, and there was no danger there. There was no home invader. There was nothing like that. In the days leading up to the offense, there were no indications that this was something that was predictable that was going to happen. Analysis of the phones of both of them showed their relationship was good. According to the child who was there in the home, there was no argument in the immediate lead up to it. There was an argument earlier in the day in which they were arguing about money related to the child's father owing them money and a need to possibly engage in civil suit for that. What happened is at some point in the day, Michael Winquist, who had not been sleeping for days, had been drinking constantly for days, was on what you might call a bender, suddenly was heard by the child who was in the basement, suddenly wake up, crashing around the bedroom, stumble to the kitchen. He heard a gunshot. His first thought was, well, Michael Winquist often will like shoot like squirrels and varmint and things like that, until he heard a body drop. And then he went up and found the image of Michael Winquist in front of his mom with a gun with her bloody on the floor. He fled, and when he was outside, he had to watch Michael Winquist shoot himself.
This is where the case shifts from tragic to chilling. A child hears a gunshot, sees his mother bleeding on the floor, then watches the shooter turn the gun on himself. That's not just evidence, it's generational trauma. How does the justice system account for damage done to witnesses who never chose to be part of the crime?
He wasn't sure if Winquist was dead or not. Later on, he would go back in and remove the firearm. Michael Winquist was there ineffectually doing some sort of care to the head wound while mumbling something about dreaming. The victim, Christina Fickbaum, miraculously survived. She survived a gunshot wound to the head. In fact, she walked herself out of the building to EMS outside. The injury that she really was inflicted with wouldn't become apparent until later. In fact, if you watched her right after the incident in the hospital, you wouldn't detect any sort of impairment in how she's interacting at all. None of the cognitive or neurological issues that you've heard from the victim statements today. That was an injury that has worsened and festered and grown and gets worse with time after the injury was inflicted, the initial gunshot. At that point, law enforcement asked her the question, what happened? And she couldn't remember for obvious reasons. She was shot in the head. They asked her, do you have any idea why this happened? And she couldn't give an explanation. The person who had been living with him didn't know. The best she could do was speculate it's associated with his PTSD and him fighting in his dreams. But she didn't know the answer. In the PSI, she was interviewed by the PSI writer, as well as many family members and other people who just know Michael Winquist, where it was discussed that he's violent. He engages what one might call domestic violence, offering another possible explanation for what might have happened. Nobody really knows, though, because of the lack of memory, what actually caused this. I'm going to come back to that later. Michael Winquist at the time was on probation. He was on probation for felony OWI. He is prohibited by the conditions of probation from consuming, possessing alcohol. Absolute sobriety. He was prohibited by the law, because of the felony nature of the conviction, from possessing firearms. In the PSI, he specifically talks about that shotgun in the closet. Why do I have it? It's for the purpose of protection. That is not allowable for someone who is a felon. You can't just keep it for protection, or else the prohibition would mean nothing. She's been inflicted with devastating physical, mental, emotional, neurological injury. And they're an injury that worsens with time. It doesn't get better. This is a victim that cannot and will not ever be made whole, either through anything the court can order, through any restitution that Mr. Winquist could do, because the way she's going to experience life from now on is forever changed. As far as I can tell, the worst injury, the worst impact on a victim I've ever seen in a case short of death. The state's recommendation, 17.5 years initial confinement, 10 years extended supervision. That's not going to be the rest of Mr. Winquist's life. He'll get out almost at age 50 if the court follows that recommendation. It is more than half his life that he's lived so far. It is more than the adult life he's lived so far, but it's still less than what Christina Fickbaum is going to be facing going forward, because we know the nature of her injury. It's degenerative, it's treatable, but not curable, if that makes sense for the court, if it understands that terminology. I've alluded to in the past hearings, that was the main thing police were trying to figure out. We were trying to find a motive. We were trying to find sense in something that was utterly senseless. It turns out it was a folly. And that's exactly why I think these factors do not bode well for Mr. Winquist. This was not a violent action in regards to a hot argument. This was not, what we call a hot homicide where, hey, the child in the basement heard them having a loud argument and fighting and then escalating. This wasn't that. So we can't say it was that. Could have been any of the things I described. With the PTSD, what's even the source of the PTSD? He served in the military, but he served in a non-combatant role. Could it be the shooting that happened that was alluded to by the victim advocate? Well, Mr. Winquist was simply standing outside a bar. He was shot in the buttocks by a scope rifle for really no reason at all. He did. But the real reason why I'm talking so much about there's not a good explanation for his behavior is because that is the sort of thing we look at when thinking about incapacitation. The reason I'm recommending a 17.5-year initial confinement sentence, even though Compass and the Department of Corrections says this is a low-risk offender, is because the community needs to be protected from him.
This is the heart of the state's argument: unpredictability. Not rage. Not motive. Not even intent, just that nobody saw this coming. And legally, that's terrifying. If a person can't explain their own violence, how can society trust it won't happen again?
Nobody saw this coming. If you asked the day before this of Christina or her child, is she going to get shot tomorrow? None of them would have even fathomed they would have been anywhere near that. Michael Winquist's behavior is not predictable. It's like trying to predict a wild animal, whether or not it's going to strike or not. And that's the real danger, and why incapacitation, to me, overrides even specific deterrence and rehabilitation in this case.
Ms. Fickbaum and all of her friends here to understand that I am not in any way blaming Ms. Fickbaum. She was the victim of a crime, a very serious crime, and she deserves everyone's sympathy and concern. But she's involved, was involved, and remains involved in the context that led up to May 31st, 2024. He considered the two of them married. The initial video that I saw of an interview with Mr. Winquist and law enforcement showed him wearing a wedding ring. He wore that wedding ring for many months.
I need to stop. Is she leaving and vacating or just using the restroom?
I don't know.
I just need to ensure that I'm gonna still be in victims' rights compliance.
He needs to take a break.
Okay, we need to take a break.
Sure.
All right, let's take,
She doesn't want to hear this. Yeah, that's it.
okay, this part she doesn't want to hear, but then she'll come back.
Yeah.
Okay. Mr. Harrington, you may continue.
Thank you, Judge. He wore the wedding ring in jail for months. I can't tell the court when he took it off. He considered that they were married. They weren't, but he considered it. The court is probably aware that he received a substantial financial award because of the accidental shooting. And he, pursuant to the plea, or the PSI, he gave her $75,000 because he thought they were gonna stay a couple. He needed expenses, the money to pay some expenses in the house. As Mr. Schmidt noted, there was nothing on the couple days before May 31st of 24 that suggested that this event was going to happen. They consumed the most destructive substance in our society, alcohol. Michael's mother told the agent that her observation was that they played drinking games. Alicia Johnson, Ms. Fickbone's son's girlfriend, opined that both Christina and Michael drank too much. They drank together. So that's the circumstance that makes this tragedy somewhat predictable. Law enforcement discovered a number of firearms. They discovered the shotgun, which was out in the bush, and the child had thrown it there. They discovered a loaded handgun in the kitchen drawer. Loaded in that the magazine was in the butt, in the drawer. And that was Christina's handgun. They discovered in the basement closet behind a dresser a loaded Remington 30-06 rifle. They discovered a loaded 22 Marlin rifle and a loaded 22 caliber Mossberg rifle, all kept in the basement. So these folks were consuming alcohol and had loaded firearms in and about the house. The tragedy was predictable. The date was not. They had consumed considerable amounts of alcohol. The discovery reflected that both Michael's blood alcohol, this was 0.215, Christina's was, and I'm not sure where I got this number. Christina's, per my notes, was 0.297. We don't know precisely the sequence of what happened because, according to the discovery, neither Michael nor Christina could remember a sequence of events. We do know that Michael had napped, had a bad dream, woke up, grabbed the shotgun, fired it, striking Christina in the head. And final note, Michael paid the $10,000 initial payment on restitution a couple months ago. And he tells me he sent another check for $2,582.23 to the court just within the last couple of days.
It
The
was
restitution
confirmed.
request has been paid.
It has been confirmed that that has been paid. So what is the total initial and total extended supervision you are requesting?
10 years, 4 years ES. 10 years initial confinement, 4 years ES.
All right. The victim is now back in the courtroom. Mr. Winquist, I'm now going to give you an opportunity to tell me anything that you would like me to know.
I'd like to make an apology to Christina. I'm beyond sorry for what happened that night. It's so unfair what happened to you, and I will regret that moment for the rest of my life. I think about it every day and hate myself. I would give anything to change the outcome. I'm deeply sorry and hope the best for you. You should have never had to deal with that trauma, that situation. Very sorry. And also to all your family and friends that I've had to take care of you because of my actions. I know none of this changes anything for you, and I will mourn this for the rest of my life. Sorry.
You have admitted here to these very serious crimes through a plea agreement with the state. Count 1 was amended down from attempted first-degree intentional homicide, domestic abuse. It was amended to a second-degree reckless causing injury with a domestic abuse enhancer, as well as use of a dangerous weapon enhancer or modifier. If you were to have been convicted of the original charge of attempted first-degree intentional homicide, domestic abuse, upon conviction, you may be sentenced to a term of imprisonment not to exceed 60 years. And then that was amended down to the second-degree reckless injury with the domestic abuse enhancer and the dangerous use of a dangerous weapon modifier, where the maximum possible penalty could be the initial 12.5 for the second-degree reckless, with the ability to increase an additional 5 years of initial confinement because of the use of the dangerous weapon and that modifier. All in all, due to the agreement that you've reached with the state, the plea agreement, you essentially avoided a life sentence. Ms. Fickbaum does not have the same ability to avoid that life sentence. She will continue to live with this day in and day out, not only the emotional turmoil and effects, but the physical effects that she has and will continue to suffer from, which then leads to financial effects and other mental health effects and other things that will seep and continue to seep into her life. You may not have killed her, but her life left her that day. There are allegations of domestic abuse between you and the victim and you and your ex-wife. I don't have anything that confirms that. I don't have that you have a criminal history as it relates to that. I don't even have a criminal history of violence with you. It's all alcohol related for the most part, except for perhaps your 2018 conviction for obstructing an officer. But if I look at the underlying facts, I'm going to guess it probably had alcohol relation. And you're nodding your head up and down, so that tells me it did. You have an alcohol problem. You are an alcoholic. You cannot, you should not in any way, shape, or form ever touch a drop of alcohol. It was stated that OWI fourth conviction changed your life. I don't see it changed your life at all. Not one bit. You continued to drink alcohol while you were on probation. The only thing your OWI 4 conviction changed your life in was it took away your right, your privilege actually, your privilege to be able to operate a motor vehicle and have a driver's license, because it took it away for life. But I'm going to tell you, I don't believe for 1 minute that you didn't drive illegally after your OWI 4th conviction. Perhaps you didn't on this day, as your attorney said, because he said this changed your life because you were no longer able to drive, and it appears he wasn't driving the day of the incident. But the fact that you couldn't abide by your probation conditions, the fact that you continued to drink alcohol after your OWI 4th conviction while you were on probation, the fact that you continued to possess firearms when you are a convicted felon leads me to believe that you wouldn't follow the lifetime restriction of no driving or having a driver's license either. That you were shot with a rifle during an incident. I remember that day, not that day, but I remember that incident very clearly because that impacted your OWI 3rd conviction in front of me. That incident occurred when you were at a bar. You were standing up outside or something like that. The individual was cleaning his rifle in a house across the street. There was a cord on the floor. He was walking with the rifle. Somehow the safety wasn't on and it was loaded. Those are no-nos. But he tripped and fell. The gun shot through his glass sliding door, shattered the door, went across the street, went to the area on the bar's property where you were and struck you in the buttocks. Accident. It was an accident. This incident was on purpose. It wasn't an accident that you picked up a shotgun, you pointed it at your girlfriend at the time, you pulled the trigger, and you shot her in the head. That wasn't an accident. No matter how many people don't remember what happened or the incidents that occurred that day, or what was going through your mind, that was not an accident. Yours was an accident. Your PTSD, if you have it, and that's been said that it could be from that, or could be from this or that or the other. Any trauma that you have suffered from your shot in the buttocks, completely, 100%, totally different than the trauma that the victim here suffers from. Because she had somebody who said, I love you. She had somebody who said, from the words of your counsel, you thought you were married. You wore a wedding ring and you pledged yourself to her life, to her betterment, to make her a better person and to have this life. And you picked up that weapon that you had no legal right to possess, and you shot her in the head. It's not all on Miss Fickbaum's shoulders because it was her house. You live there too, and as you said, you felt she was your wife. It's not all on her shoulders. You as the felon, you on probation, you are the one who knew that any weapons in that home needed to be under lock and key, or they could not be in that home. And you were not able to have access to that key. And especially because the court views the fact that you were on probation, you had a no drink of alcohol prohibition, you had a no firearms prohibition, and that one's for life. The court finds that that is an aggravation of this incident, and it aggravates what happened that day. And although Ms. Fickbaum may have engaged in alcohol consumption that day, and she may have been extremely intoxicated as well, she in no way played a factor in you taking that weapon, you taking that gun and shooting her in the head. None of that, none of it is her fault. None of it. So with count one, the court is going to sentence you for the underlying second-degree reckless injury, 7.5 years of initial confinement. And then the maximum for the use of the dangerous weapon, totaling 12.5 years of initial confinement with 5 years of extended supervision. As it relates to count 2, possession of a firearm, convicted felon, the court also finds this egregious. The fact that he knew he was a convicted felon, as applied to him, it was very serious. He was simply just on probation not too long before that. The court finds that a maximum of 5 years of initial confinement and 5 years of extended supervision is necessary. Counts 1 and 2 are consecutive to each other. As to count 3, possession of a firearm by a convicted felon, that is still serious and egregious. No matter where the firearms were placed, he knew of the prohibition. He knew that that was for life. He was still on probation. He was on a no alcoholic drink prohibition. He was extremely intoxicated. The court is going to sentence him to 3 years of initial confinement with 3 years of extended supervision. That is consecutive to counts 1 and 2. Possession of a firearm by a convicted felon. The court finds the same. 3 years of initial confinement with 3 years of extended supervision. That is going to be consecutive to counts 1 and 2 and concurrent with count 3. For count 7, possession of a firearm by a convicted felon. The court also finds the same things as to counts 3 and 6. 3 years of initial confinement, 3 years of extended supervision. That is consecutive to counts 3 and 6, consecutive to counts 1 and 2.
Judge, did you say consecutive or concurrent? 7 is concurrent with 6 or consecutive?
Consecutive. It's consecutive to all counts. Count 8, possession of a firearm by a convicted felon. Same basis. 3 years of initial confinement, 3 years of extended supervision. 8 is concurrent with count 7, but consecutive to counts 3 and 6, and consecutive to counts 1 and 2. In my calculation, it's 26.5 years of initial confinement, and I believe 16 years of extended supervision.
26.5 years in prison. 19 years under supervision after that. This isn't about revenge, it's incapacitation. The judge makes it clear this was preventable, and the system failed to stop it sooner. Final question for you: does this sentence feel like justice, or does it feel like the cost of waiting too long to intervene?
The court finds this to be so egregious, so serious, and so preventable. Had Mr. Winquist recognized his problems and did something about it, he did not. He failed to do anything, and he had sign after sign after sign, and he failed to even recognize or address them. And he is not eligible for early release programming, either the challenge incarceration program or the substance abuse program. The court is ordering $12,582.23 in restitution. I believe I've covered everything, Mr. Schmidt.
Just to clarify, I think I wrote down wrong about 3, 6, 7, and 8. The court ordered 3 and 3 out on all of them. They're all consecutive to counts 1 and 2. 3 of them are consecutive to each other. 1 of them is concurrent to that group, totaling 26.5 and 19 out.
19 out? You could have added the ES correctly. I didn't write down the ES. I was trying to do it by my head.
Okay.
So,
Did I state the rest correctly?
correct.
Okay.
Anything else that is missing, Mr. Schmidt?
That wasn't missing. I think I just heard wrong.
Mr. Harrington?
No.
All right, then